11 Salient features of the Indian Constitution. Number 1. The lengthiest constitution in the world. The Indian Constitution is the lengthiest and most detailed of all the written constitutions of the world. While the American Constitution originally considered of only 7 articles, the Australian Constitution 128 articles, the Canadian Constitution 147 articles, the Indian Constitution originally consisted of 395 articles divided into 22 parts and 8 schedules. But after the Constitution 92nd Amendment Act, 2003, the Indian Constitution now consists of 444 articles divided into 26 parts and 12 schedules. Since 1952, several articles have been repealed and 64 more articles have been added to the Constitution. The new articles are as follows: 31, a 31b, 31c, 39, 43, a 48, a 51, a 134, a 139, a 224, a 226, a 228, a 233, a 239, a 239, a 239 ab, 239b, 243a to 243zg, 244, a 258, a 268, a 290, a 300, a 312, a 323, a 323b, 350, a 350b, 316, a 363, a 371a to 371I, 372, a 378, a 394a. Article 21A was added to the Constitution by the Constitution 86th Amendment Act, 2002. In 2003, 3 new articles, Articles 268A, Article 338A and Article 361B were added to the Constitution. Article 268A has been inserted by the 88th Amendment and Article 338A has been inserted by the 89th Amendment Act, 2003 and Article 361B has been added by 91st Amendment Act, 2003. Number 2. Parliamentary form of government. The Constitution of India establishes a parliamentary form of government both at the centre and the states. In this respect, the makers of the Constitution have followed the British model in toto. The reason for this is we were accustomed to this type of government. The essence of the parliamentary form of government is its responsibility to the legislature. The President is the constitutional head of the state. The real executive power is vested in the Council of Ministers, whose head is Prime Minister. The Council of Ministers is collectively responsible to the lower house, that is Lok Sabha. The members of the lower house are elected directly by the people on the basis of adult franchise, normally for 5 years. The position is same in the states. This government is, therefore, called a responsible government. On the other hand, the American Constitution establishes a presidential type of government based on the principle of separation of powers. The President is the real executive, elected directly by the people for 4 years. All executive powers are vested in him. He is not responsible to the lower house. The members of his cabinet are not members of the legislature. They are appointed by the President and therefore responsible to him. Number 3. Unique blend of rigidity and flexibility. It has been the nature of the amending process itself in federations which had led political scientists to classify federal constitution as rigid. A rigid constitution is one which requires a special method of amendment of any of its provisions, while in flexible constitution any of its provisions can be amended by ordinary legislative process. A written constitution is generally said to be rigid. The Indian Constitution, though written, is sufficiently flexible. It is only a few provisions of the Constitution that require the consent of half of the state legislatures. The rest of the provisions can be amended by a special majority of Parliament. The fact that the Indian Constitution has been amended 94 times during the period of last 60 years of its working disapproves the view taken by Sir Ivor Jennings, who had characterized our Constitution as rigid. Number 4. Fundamental Rights. The incorporation of a formal declaration of fundamental rights in Part 3 of the Constitution is deemed to be a distinguishing feature of a democratic state. These rights are prohibitions against the state. The state cannot make a law which takes away or abridges any of the rights of the citizens guaranteed in the Part 3 of the Constitution. If it passes such a law, it may be declared unconstitutional by the courts. But mere declaration of certain fundamental rights will be of no use if there is no machinery for their enforcement. Our Constitution has, therefore, conferred on the Supreme Court the power to grant most effective remedies in the nature of writs habeas corpus, mandamus, prohibition, quo warranto and certiorari whenever these rights are violated. It must, however, be clearly understood that fundamental rights are not absolute rights. They are subject to certain restrictions. Thus our Constitution tries to strike a balance between the individual liberty and the social interest. The idea of incorporating a Bill of Rights has been taken from the Constitution of the United States. But the guarantee of individual rights in our Constitution has been very carefully balanced with the need for security of the state itself. Number 5. Directive Principles of State Policy. The directive principles of state policy contained in Part 4 of the Constitution set out the aims and objectives to be taken up by the states in the governance of the country. Unlike the fundamental rights, these rights are not justiciable. If the state is unable to implement any provisions of Part 4, no action can be brought against the state in a law court. For this want of enforceability there has been much criticism. But the criticism is not justified. Though by their very nature they are not justiciable in the court of law, yet the state authorities have to answer for them to the electorate at the time of election. The idea of a welfare state envisaged in our Constitution can only be achieved if the states endeavor to implement them with a high sense of moral duty. Number 6. A federation with strong centralizing tendency. The most remarkable feature of the Indian Constitution is that being a federal constitution, it acquires a unitary character during the time of emergency. During the proclamation of emergency, the normal distribution of powers between the center and the states undergoes a vital change. The Union Parliament is empowered to legislate on any subjects mentioned in the state list. The central government is empowered to give directions to states as to the manner in which it should exercise its executive powers. The financial arrangements between the center and states can also be altered by the Union government. Thus, during the proclamation of emergency, all powers are centralized in the Union government and Constitution acquires a unitary character. This combination of federal and unitary system is unique feature of the Indian Constitution. This feature of the Constitution can be better understood in the historical background upon which the federalism has been introduced in India and also in the light of the experience in other federal countries. Number 7. Adult Suffrage. The old system of communal electorates has been abolished and the uniform adult suffrage system has been adopted. Under the Indian Constitution, every man and woman above 18 years of age has been given the right to elect representatives for the legislature. This suffrage is wider than all the democratic countries which have given right to vote their people. In spite of many difficulties, this bold experiment has been crowned with success. This is evident with the increased number of voters on the electoral rolls in the general elections. Number 8. An independent judiciary. Mere enumeration of a number of fundamental rights in a constitution without any provision for their proper safeguards will not serve any useful purpose. Indeed, the very existence of a right depends upon the remedy for its enforcement. Unless there is remedy, there is no right, goes a famous maxim. For this purpose, an independent and impartial judiciary with a power of judicial review has been established under the Constitution of India. It is the custodian of rights of citizens. Besides, in a federal constitution, it plays another significant role of determining the limits of power of the center and states. Number 9. A secular state. A secular state has no religion of its own as recognized religion of state. It treats all religions equally. The preamble declares the resolve of the people of India to secure all its citizens liberty of belief, faith and worship. Articles 25 to 28 of the Constitution give concrete shape to this concept of secularism. It guarantees to every person the freedom of conscience and the right to profess, practice and propagate religion. In a secular state, the state only regulates the relationship between man and man. It is not concerned with the relationship of man with God. One may worship God according to the dictates of his own conscience. However, it is to be noted that the freedom of religion is not an absolute freedom, but subject to the regulatory power of the state. In the name of religion, nothing can be done which is against public order, morality and health of the public. Secularism is also subject to democratic socialism. Religious freedom cannot, therefore, be used to practice economic exploitation. The right to acquire, own and administer property by religious institutions is subject to the regulatory power of the state. Number 10. Single citizenship. Though the Constitution of India is federal and provides for dual polity, that is center and states, but it provides for a single citizenship for the whole of India. The American Constitution provides for dual citizenship, that is the citizen of America and a state citizenship. On the other hand, there is only one citizenship in India, that is the citizenship of India. There is no state citizenship. Every Indian is the citizen of India and enjoys the same rights of citizenship no matter in what state he resides. Number 11. Fundamental duties. The Constitution, 42nd Amendment, Act, 1976 has introduced a code of 10 fundamental duties for citizens. The fundamental duties are indeed to serve as a constant reminder to every citizen that while the Constitution has specifically conferred on them certain fundamental rights, it also requires the citizens to observe certain basic norms of democratic conduct and democratic behaviors.